Hello, I am Elda Lebenamar and I hired Mr. Davis on October 2014. My granddaughter was removed from my home and I was told that as a grandparent I had no rights and that my granddaughter will soon be put on the list for adoption. She was put into foster care and I heard of Mr. Davis. I researched and I hired him. The judge told Mr. Davis not once but twice to sit down while we were on the process of trying to talk to the judge. Mr. Davis did not take no for an answer.
Good morning. Welcome to CPS Office Hours. I'm Attorney Vince Davis, and today we are discussing a heartbreaking but important topic: how false medical diagnoses can lead to CPS cases and how to fight back. The reason why I picked this topic is because yesterday I spoke to someone who was going through this very thing, and it's a scenario that I see maybe 10 to 12, 15 times a year. So it's relevant. It's highly relevant for people who lose their children through a false medical diagnosis. This is one of the most terrifying experiences for any parent. You trust doctors to help, but sometimes a wrong diagnosis starts a CPS nightmare. Stay tuned. If you find this helpful, please donate to keep this mission alive. Segment 1. How medical reports trigger CPS investigations. Doctors and nurses are mandated reporters. They must report suspected child abuse. Common triggers for these reports are bone fractures in young children, bruises, internal injuries, sometimes caused by something referred to as shaken baby syndrome, failure to thrive or manipulation or malnutrition allegations, and then positive drug tests of newborn babies. Doctors are supposed to be trained to, quote, see something, say something, even with little evidence. Hospitals often contact CPS before even asking the family for explanations. Here's a real life example: misdiagnosed brittle bone disease, osteogenesis imperfecta, mistaken for child abuse. Many years ago, I represented a young man who was allegedly a gang member. The child had several broken bones, very young child, baby. And he swore to me that he had not done anything to the child. And of course, the mother agreed and said she hadn't done anything to the child. Well, prior to the trial, one of my mentors told me something about osteogenesis imperfectus, which is otherwise known as the brittle bone disease. And it is just what it sounds like. And it's predominantly in, but not only in, the Latino community. And my client was Latino, and so was the mother. So I asked for a medical test of the child to determine whether the child had brittle bone disease. That took a while, the testing, and this was several years ago, so the technology wasn't what it is today. But during the entire process, my client was also criminally prosecuted, and the family came to me to handle his criminal prosecution. My client was out on bail, and while out on bail, he became so frustrated for being wrongly accused that he and the child and the mother took off after or during one of the visitations he had with CPS through foster care. And he disappeared for several years, and the cases were being continued because of that. Well, during his disappearance, the results came back on the brittle bone disease. And wouldn't you know it, the child tested and did have brittle bone disease. The test showed that the child had this genetic malady of brittle bone disease, and this was the explanation for the child's injuries. Only thing was, my client wasn't around. Well, a couple years went by, and my client apparently had come back to the United States, was back in Los Angeles, and he got stopped by the police for a minor traffic infraction. They realize who he is, that he has a bond, bailout or bond on him, a warrant on him, and he's arrested. We're brought to court, and I'm able to get the juvenile case resolved. No child abuse on his part. Problem was the criminal case. Went to criminal court, and the DA agreed that they couldn't prove the the physical injury on the child because of the brittle bone diagnosis. However, the DA wanted to go forward with a new count against my client for kidnapping. And for whatever reason, the DA thought, and I was a younger attorney, the DA thought, well, Davis will just have him plead out to kidnapping because, allegedly this was a kidnap. And I told the DA and the judge on several, conferences that if you were accused of child abuse, facing losing all of your children, and you were facing criminal sanctions or, possibly going to state prison, where allegedly they don't treat alleged child abusers so nicely, what would you do? So I was hoping to take the case to trial and get what's called a jury nullification verdict, that at least one or two people would not vote for him to be guilty, even though technically he might have been, because of the situation. And the case was actually, I believe, set for trial. And oddly enough, in the end, when they saw that I was definitely going to go to trial and looking for a jury nullification, the charges were, I think they were dismissed. And that was the end of that story. But I bring it up only because of what a medical misdiagnosis can lead to. All right, the next segment is that I want to talk to is what to do immediately if CPS is involved on a medical report. First thing you should do is hire experienced counsel right away. Hire independent medical experts, kind that will do the test for brittle bone disease. Request copies of all hospital records. This may be difficult because CPS might try to stop you and stop the hospital from giving you medical records that you are entitled to. You should document everything: conversations, medical reports, timelines of events, and do not argue with CPS or hospital staff. They will definitely use it against you. You cannot talk your way out of a CPS case. You must document and defend. All right, the next segment is building your defense with medical experts. Talk to your lawyer about hiring specialists, pediatricians, geneticists, radiologists, neurologists. Request second opinions. Court-authorized medical exams. Gather family medical histories. In California, and I would suspect in other states, if you can't afford these experts, there are motions that your attorney, court-appointed or private, can make to have experts appointed. There's a doctor here in Los Angeles County that a lot of defense experts use, and who's very well known. I think he's like a 35-year doctor, and he one of his expertise is child abuse. And I have hired him, and I've known many of my colleagues that have hired him to review records, X-rays, and reports. And he's very, very credible, very honest. I mean, he's the type of guy that if he reviews the records and he doesn't think we have a defense, he would tell me. But in a lot of cases where I've hired him, he's told me, oh, they think this is child abuse, and it's not. And here's why. So he would have to come to court and testify. During COVID, when the courts were closed, I did a case of suspected child abuse in Sacramento County, and we hired him to examine the records, the X-rays, etc. And because of his testimony, we won the case, got the child back, or got the children back. There were several children involved. And one of the things he told me, which of course I wouldn't know because I'm just an attorney, he was able to look at the X-rays and determine the approximate date of the injury, the broken bone. And it dated back to a time where the child was in intensive care in the hospital, somewhere in Sacramento County. And then he further realized from reviewing detailed medical records the probable cause of the injury. The probable cause of the injury was a nurse giving CPR to the child, trying to resuscitate, bring the child back. And the rib cartilage was fractured during that because the person giving the CPR was giving it the wrong way. Apparently, and I didn't know this at the time, apparently you give CPR to an adult one way because their bones are developed and hardened. But a young baby, you give CPR a different way because they don't really have bones yet. Those ribs and things are cartilage, very easily broken if you're giving CPR the wrong way. Well, the doctor testified to this. The doctor from the hospital testified otherwise. Luckily, the judge found it true our way, and that it wasn't child abuse and it was probably caused by hospital staff. Interestingly enough, one of the things that also came up during our investigation that there were several medical malpractice claims and lawsuits against this one hospital for medical malpractice relating to injuries to children. That may have also been another factor. So you see how getting the right expert can help you out in the case. The next segment is court strategy for fighting false medical CPS cases. One of the things you and your attorney must do is demand discovery immediately. Depose the hospital staff and doctors if you can. Cross-examine CPS social workers about their medical training, which is usually none. File motions to exclude unreliable medical evidence, and force CPS to prove serious physical harm with real science. The other day I was doing a trial, and I had a social worker testify that she believed my client was a risk because of a mental and emotional condition for an event that happened about three months prior. And she came to a conclusion, and on cross-examination, I asked her, was she trained or qualified to give such an opinion about my client, the fact that he was a risk because of that one incident? And to her credit, she admitted that she wasn't trained. And she admitted that probably the police officer who was involved in the incident wasn't trained to make that conclusion either. So sometimes social workers do make conclusions based upon medical science that they're not qualified to make. All right, segment 6, mistakes parents often make in medical CPS cases. Number 1, trusting CPS to understand later. Number 2, failing to demand independent medical exams. That's an important one. Number 3, not attending every court date. 4, speaking emotionally rather than factually. And number 5, signing voluntary case plans without understanding the consequences. As I've said many times before, don't sign anything without talking to your lawyer. You have to fight early, you have to fight hard, and you have to fight smart. If you're facing a CPS case based on a medical report, remember, CPS believes the doctors first. You must disprove their assumptions. You need independent experts, you need documentation, you need an experienced legal team. I want to invite you to join our Fight CPS School, skool.com, for ongoing support, templates, and weekly trainings. And if this video has helped you, please consider donating to support families fighting false accusations so that we can keep this channel going. I'm Attorney Vince Davis. Thank you for spending time with me today. Stay smart, stay determined, and I'll see you the next time on CPS Office Hours. Before we go today, I'm going to take some questions from the audience. My little comment section here is blowing up. Betty Jo from Winderhold from Facebook. Good morning. Good morning, Betty Jo. Betty Jo says, what happens when they take the child and keep the child and they say that there's a bond with the foster parent and not allowing to go with the family? Well, you have to, Betty Jo, you're going to have to get a lawyer. You're going to have to prove that that's not true. There are federal regulations which control all of these CPS proceedings. And one of the overriding concepts is the child be placed with family. And what happens often, I see it all the time, the family doesn't come forward fast enough, right? And they leave the child in foster care. And what happens when you leave children in foster care? Well, they develop bonds, emotional, psychological, physical, with people that take care of them. Listen, if you were a person, not even a minor, if you go someplace and you're not able to care for yourself and you're being taken care of by a person who feeds you, who gives you emotional support, who hugs you, um, who takes care of all your problems, you're going to form a bond physically, emotionally, and psychologically. Now, as these bonds develop, sometimes social workers and judges believe, well, the family didn't come forward fast enough. And unfortunately, this child has formed a bond with the foster care person. And if you remove that child from the foster care person, that the theory is that will cause injury, psychological, emotional injury to the child. And, I have to be honest, in some cases that might be true. However, you have to prove to the judge that being placed with a child, being placed with a family member outweighs that bond that may have been formed between the child and the foster parent. So if you're a relative or if you're a parent and you want to get this child to a relative, you got to do it early in the case. Early in the case. All right. Betty Jo says, and the pediatrician says that she has a bond with the foster mom. I'm not sure the pediatrician is qualified to say that, but maybe based upon his just common experiences from what he's seen between him and between the foster parent and the child, he might opine that. So if you're a relative, come early and try to get the child placed with you and keep trying. Betty Jo, I'm not sure what state you're in, but there are many things that you can do to try to get the child placed with you. Many things, including filing complaints with the federal government, the Department of Justice, Civil Rights Division, and then there are many things that you can file in the juvenile court to have the child placed with you. All right, so Betty Jo, talk to an experienced attorney about your situation. All right, Margaret King, a member of our YouTube channel from YouTube, says, "Good morning, Mr. Davis. CPS social worker took pictures of my 5-year-old's legs. Get a doctor rebuttal what CPS is claiming as abuse from pictures." Okay, Margaret, I'm not really sure what you're saying there, but maybe you can try again or call me later. Margaret says, "Can a doctor rebuttal CPS claims as abuse from the pictures alone?" Yes, but if there was an examination, it would make that testimony stronger, right? Margaret says she wasn't taken to a doctor. Sometimes that helps them or hurts them. I'm not sure. I'd have to know more about the situation. All right. Looks like we don't have any further questions. I'll wait a minute to see if anyone wants to post anything real quick. Also in the future, you guys, underneath my nose on the screen right there is a telephone number where you might be able to call in and ask me questions. And I can put you on screen. That means if you don't want to come on and be a video guest. Margaret says she obtained she obtained a little bruises on the shins of her legs from playing on the swings and other scooters. It definitely helps to have a doctor examine that to see how she got it, or to interview her and see how she got those injuries. I'm just assuming she's old enough to talk. All right. No other questions this morning? So thank you everyone for watching, and we'll see you tomorrow on my CPS office hours. Stay safe.
On May 2016, like Mr. Davis promised, my granddaughter is home, and I am in the process of adoption. I can only say it's a horrible nightmare. And if I did not have Mr. Davis pulling us through, it would have been another denial, and my granddaughter would not have come home. I thank Mr. Davis from the bottom of my heart for taking my case. Thank you.